So you probably know that employment discrimination is illegal, but do you know all the ways that illegal employment discrimination happens in the workplace? Well, you're in luck. I'm an employment lawyer, and in this video, I'm going to detail the different theories of discrimination. That is, all the ways that illegal discrimination happens in the workplace. So stick around. Before I begin, nothing in this video is legal advice. If you think you were discriminated against at work, talk to an employment lawyer in your jurisdiction. If you're in Washington State, feel free to reach out to my firm. The link to my website is in the description below. Okay, let's get to it. So before we talk about all the ways that employment discrimination arises in the workplace, let's talk a little bit about how the law defines discrimination. It will be important later in our discussion. To do that, we'll first look at the law. Our protections against discrimination arise originally in the Civil Rights Act of 1964. Most states have also enacted their own anti-discrimination statutes that supplement the Civil Rights Act of 1964. But all workplace discrimination is based on the same language originating in that Civil Rights Act of 1964. The specific part of the Civil Rights Act that we'll be looking at is called Title VII, and specifically, we'll be focusing on Section 703, subsection A. That section reads, "It shall be an unlawful employment practice for an employer to discriminate against any individual with respect to his compensation, terms or conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin." So to put it simply, Title VII's anti-discrimination provision outlaws discrimination in compensation, terms or conditions of employment, or privileges of employment because of protected characteristics. But that discrimination can happen in any number of ways. So let's talk about each way that discrimination can arise in the workplace. So there are three main theories of discrimination that, if they occur, they trigger the protections of Title VII or the protections of the state-specific statute that outlaws discrimination in your state. These three theories of discrimination are known as the following. First, disparate treatment. Second, disparate impact. And third, hostile work environment. So let's outline all three of them, and I'll provide some examples too. So first, we'll talk about disparate treatment. Now, disparate treatment is the most obvious form of discrimination. It's the type of discrimination you probably think of when you think of employment discrimination. It simply means that an employer took an adverse action against an employee because of that employee's protected characteristics. That adverse action can be discharge, demotion, change in benefits, change in compensation, failure to hire, or failure to promote, or anything else that changes the worker's terms or conditions of employment. Remember back to our language from Title VII. It needs to change the compensation, terms, conditions, or privileges of employment because of the employee's protected characteristics. And disparate treatment can be a difficult form of discrimination to prove because it requires discriminatory intent on the part of the employer. The employer must have the intent to discriminate against the employee because of the employee's protected characteristics. Now, the employee's protected characteristics need not be the only motivation for the employer's decision, but it needs to be a motivating factor. In Washington law, we call that the substantial factor test. An example of disparate treatment discrimination would be a hiring manager refusing to hire a woman based on his concern that the woman will have to take time off later in her employment to take care of her child. He took an adverse action against the woman by failing to hire her. She was in a protected group because sex and gender is a protected characteristic, and he was motivated by her protected characteristic. The next theory of discrimination is known as disparate impact, and it occurs when an employer has a seemingly neutral policy that negatively and disproportionately impacts workers who are members of a protected group. Unlike disparate treatment, disparate impact does not require discriminatory motive. Instead, affected employees need only show the consequences of that neutral policy and how they fall more harshly on the protected group. For example, in a case here in Washington State called Kumar versus Gate Gourmet, the employer had a policy of not allowing workers to bring lunch to work and instead providing the workers their lunch. The problem was that the employer failed to provide vegetarian options, and a group of these employees were members of a religious group who could not consume meat. So the company's policy forced these employees to either consume meat in violation of their religion or go hungry. So while the policy didn't explicitly discriminate against any group, it fell more harshly on this protected group because religion is a protected characteristic. The policy had a discriminatory impact on the terms or conditions of employment because being able to have lunch at work is a condition of employment. Now, the final theory of discrimination is called hostile work environment. But this form of discrimination is most commonly referred to as harassment. But hostile work environment is a specific kind of harassment that triggers those protections we talked about from Title VII, or the state-specific statute that outlaws discrimination in your state. Remember back to the language from Title VII, discriminating in terms or conditions of employment because of a protected characteristic. So if a manager harasses an employee and the harassment is so severe or pervasive that it alters the employee's ability to do their job, and the manager's conduct is based on or because of the employee's protected characteristic, then that's discrimination because it impacts the employee's terms or conditions of employment, their ability to do their job, and it's based on the employee's protected characteristics. And that form of discrimination is called a hostile work environment. For more information on hostile work environment, I made an in-depth video that you can view by clicking on the link. I'll put it up here. In that video, I explain the criteria that a worker must prove in order to establish a claim of hostile work environment. An example of hostile work environment discrimination would be a manager making misogynistic jokes every day for a period of time to a female worker, making her feel uncomfortable or even unsafe. Okay, so now you know the three kinds of illegal employment discrimination. The law refers to these theories of discrimination as disparate treatment, disparate impact, and hostile work environment. But discrimination is a complex area of law. To learn more about discrimination, check out my guide. I have a link to it below in the description. If you think you were the victim of illegal employment discrimination, talk to a lawyer in your jurisdiction. If you're in Washington State, you can feel free to reach out to my firm. The more we hold employers accountable for their wrongdoing, the more we prevent them from harming other workers. Okay, that's all for me this week. See you next time.